All right, good morning, good morning, good morning, everyone. It is Wednesday, June 21st, and welcome to our forum, or at least our forum's video channel. For those of you who are not part of our forum, we're the Ontario Real Estate Legal Discussion Group, and I encourage every one of you to sign up. We do stuff like this all the time, and it's a pleasure seeing you here today. Just a couple of administrative notes before we get cracking. First, my artificial background looks even more fake than normal, so you may see me change it throughout until I find one that I'm satisfied with. Number two, our forum is public, our forum is private, although as I've said before, I'm not sure how private you can be with 13,000 people, but these videos are public. What that means is that anything that is said as part of these discussions will in fact be recorded and shown on a variety of fora. Be advised that any questions you have will accordingly be out there in the public. I would mention to you that we are lining up some great talks come July. We are going to be doing one on title insurance, and we're going to be doing one on power of sales, and then we have one specifically for the agents, I believe, on Tressa. And changes that are taking place. So we have our normal stuff is kind of lining up, and we will let you know when we are 2 weeks out. Without further ado, let me turn my attention to the order of the day. I have 2 more minutes before I have to turn it over to Matt, but undoubtedly whatever I say pales in comparison to what comes out of his mouth, because Matt is, and he hates when I say this, and he will deny that I'm saying this, but I'm saying it anyways, because again, it's not me. Matt is the expert that I go to for power of sale work. And even if he doesn't want to classify himself as an expert, I would tell you that Matt has deep experience in the area of power sales. He's been trained in power sales. He works in that area. Matt is my go-to when I have questions about matters to do with power of sales. One of those matters is, of course, private payouts and discharges. Matt is here to bring us up to speed on that very topic. It is the case that in today's interest environment, many people are taking out private mortgages, increasingly so. And when those have to be paid off, private lenders sometimes, not always, many private lenders are good, many are not. When they are not, they often dictate terms and fees that are egregious. Fighting and understanding what is a valid clause and what is a valid payment and what is not is the essence of what makes us competent counsel. And Matt is here to guide us through case law and the terms that are allowed, the terms that are not. Matt, as an aside, just before I turn it over to you, every one of us at the forum is grateful both for your ongoing expertise, because many of us use you continually for questions, but also for your willingness to actually come on and speak to our group. And so without further ado, I'm turning this over to you. We're looking forward to what you have to say, and I'll help moderate both by muting people as people unmute and also guiding you through questions if you don't mind. Okay?
Great.
Wonderful.
All right, thank you. Good morning, everyone. I will just say off the top, I'm working from my my dining room table this morning. So if my dog barks or a cat walks across the screen at some point, that just might be the case. But what I'm going to do is I'm just going to share my screen and pull up a presentation because I find that will be better than looking at my face all morning. So let me just get this set up and started. Okay, I think that should be working. Can everyone see this title screen? Or Mark, can you see this title screen?
Yeah, we can see it perfectly. Thanks.
Okay, great. So we are going to be talking, as Mark said, we're going to be talking about private mortgage discharges and the discharge statements and what you can and cannot expect to see and what you can really push back on. And so to Mark's point, oftentimes you'll get a discharge statement and it's totally reasonable. It's principal, it's interest. Maybe there are some NSF fees because a few checks bounced, a bit of legal fees for the work of doing the discharge. Everyone's happy and property gets mortgage free or the mortgage gets discharged. However, just as often or almost just as often, you'll get a statement that you're expecting. You know, a client says, oh, I think it's going to be around 300,000, and you get a statement that says 350, and you're thinking, okay, well, what's that $50,000 difference? And you look and there's renewal fees that go 3 years back, and there's NSF fees, and there's a 3-month interest penalty, and there's this and there's that. And you're just looking at this going, I don't know what all these fees are, or who they're going to, or what they're for. And I also don't even know if these are enforceable. So that's what we're here to talk about, because a lot of times some of these private lenders, they like to throw as much in there as they can. And you push back a little bit and they'll say, you know what, you're right, we'll drop it. Or you have to push back a lot and they'll drop it. But a lot of these fees are not enforceable. They're not legal. They're contrary to the legislation. They're contrary to the common law. And the more you know about that, the better equipped you are to help your client when they're looking at a discharge that's way higher than they were expecting. So, couple disclaimers. Obviously, this does not constitute individual legal advice. I am not your lawyer. I am giving a presentation for educational purposes only. If you do need specific advice, obviously, please feel free to contact me after this. I'm obviously more than happy to assist on that front. For the agents and the mortgage brokers in the room, please do make sure you're consulting with your client's lawyer before disputing fees on a discharge statement. I know that, especially real estate agents, it's your job to help your clients as much as possible. And sometimes you want to get as involved as possible, but this is certainly one of those areas where I really tell agents, this is something that you can pass along this information to the lawyer and then let the lawyer handle this. Also, I act for a number of private lenders. I try to keep my lenders honest, but sometimes they'll push me to put things in that I know are going to get disputed anyway. So just, don't mention I'm giving away these secrets. Okay, so the basic first question is, what does a mortgage actually secure? I actually had a debate once with a bankruptcy trustee that said, the mortgage only secures your principal. Any interest over that principal that you're trying to get, you're not entitled to, which they were completely wrong about, but that was a different conversation. But at its core, a mortgage or a charge secures the principal money loaned, as well as the interest payable on that loan at the stated rate. So if I lend you $300,000 at 6%, that mortgage registered on that property secures that $300,000 plus the 6% interest per annum earned on that principal. It also secures any additional fees incurred by a lender in enforcing the mortgage. So if I have to go to collections on a mortgage, whether I'm a private lender or a bank, if I have to go to collections, I have to get a lawyer involved, I have to start an enforcement action, issue a claim, issue a notice of sale, those expenses, both the legal fees as well as the out-of-pocket expenses, are enforceable or collectible or secured by that charge. As well as some liquidated damages depending on how the contract is written. And then there is a form of payment penalty that may, in the right circumstances, be enforceable and collectible, and we'll talk about that. When I say out-of-pocket expenses, that doesn't just include legal fees. That can include out-of-pocket expenses. So some private lenders are very hands-on. When the mortgage goes into default, the check bounces. They're driving out to the property, they're knocking on the door, trying to find the lender. Maybe they're sending some red letters by registered mail. Maybe they're reprocessing the automatic payment 10 days later at the request of the borrower, and there's a bank charge for that. Those expenses reasonably can be collected and can be enforceable. And we'll talk about sort of where the case law is on what's reasonable and what's not reasonable. Of course, there are limits on what can and cannot be charged upon the discharge of a mortgage, whether or not that mortgage is in good standing or is in default. I always try to tell clients that are lenders, keep in mind what you contracted for, what you were expecting. If you were contracting for, $100,000 plus 10%, that's what you should be expecting to get back. If you're trying to now add on a bunch of, extra stuff because you think you can get a little bit of bonus because the person that you lent the money to is in a bad situation, that's not what this contract was for. That's not what this deal was about. And that's not how you should be going into private mortgages. So that's sort of the good person advice I try to give private lenders. So there's some key categories we're going to talk about today. Renewal fees or automatic renewal fees are always my favorite. Default administration fees, and I sort of bundled those with the NSF, which means non-sufficient funds, bank fees, bounce check fees. There's a million different names for them. The big one that's always in contention is the 3-month interest penalty under Section 17 of the Mortgages Act. Bundled in with those renewal fees is the accelerated or increased interest rates upon default, as well as legal and property management fees. So these are the different ones we're going to be touching on today. So first one is the 3-month interest penalty and Section 17 of the Mortgages Act. I will give you a heads up. This is going to get a little legislation heavy to start, but I will try and keep it in as much layman's terms as possible. It's not overly complicated, just our legislature loves to make things seem overly complicated with the language they use. Sorry, I'm just having trouble moving this one. Give me a second. Apologies. I just need to minimize this. There we go. Okay, so Section 17 of the Mortgages Act, Section 17(1), this is the text from it, and just to highlight, so despite any agreement to the contrary, where default has been made, so the mortgagee is or the mortgagor has defaulted, in the payment of any money secured by a mortgage, the mortgagor or person entitled to make the payment, so the borrower, upon payment of 3 months interest on the principal money so in arrears, can pay the same, or the mortgagor gives the mortgagee 3 months notice in writing of the intention to make payment at a time named in the notice, and in the event of making such payment on the day so named, is entitled to make the same without any further payment of interest except to the date of payment. What the heck does that all mean? In sum, where a mortgagee, or a mortgage is, I should say, is in default before the maturity date, and the borrower wants to pay the whole thing off at that point, the borrower can do so by paying 3 months interest or giving 3 months written notice that they're going to be paying it off. So they're going to keep paying for 3 more months and tell you in 3 months, I'm paying this whole thing off, along with the full principal and any interest arrears owing in exchange for a discharge of the mortgage. So basically they can compel the lender to accept an early discharge on default by paying 3 months extra interest. This is also often incorporated into the standard charge terms of a mortgage, and we'll talk about that. But this is pursuant to what's known as Section 17 of the Mortgages Act. This is a codification of what was an old rule of thumb that said 6 months interest and you can get out of it. And the reason behind this is pretty straightforward. If I lend you money and I expect to be paid interest for a month or for a year on that money, and we say, close mortgage, and you after 6 months decide, you know what, I actually don't need this money anymore, I'm going to pay it off. And I say, no, you can't pay it off, we're closed. And you say, okay, well, I'm going to default on it. And then you're going to call it in, and then I'm going to pay you back. So in order to avoid borrowers from being able to, intentionally default in order to get out of a mortgage early, the legislature codified this 3-month penalty or 3-month interest payment, so that, sure, you can default to get out early, but you're still going to have to give me those 3 months payment or the 3 months notice. So I'm going to continue getting money for those 3 months. The reasoning, or sort of the policy reason behind this from a lender's perspective is, well, I put money out to you. I was expecting to get paid for a certain period of time. Now I have to go find somewhere else to reinvest that money. So I need, 2 or 3 months to find a new borrower or a new investment product that I can put that money into, so I can continue to make, the same money I was expecting to make from our deal, because we entered into a contract to loan money. So that's the sort of the reasoning behind that, that codification of that 3-month bonus, or that 3-month interest penalty, depending on how you want to look at it. The issue arises when we look at the Interest Act, which is another statute that specifically at Section 8 says, no fine, penalty, or rate of interest shall be stipulated for, taken, reserved, or exacted on any arrears of principal or interest secured by a mortgage on real property that has the effect of increasing the charge on the arrears beyond the rate of interest payable on principal money not in arrears. So this is going to come up. The Section 8 provision is kind of the basis for a lot of our discussion today, so it's important to understand it. So what this is saying is that I cannot, as a lender, charge a rate, charge a penalty or a fine or a bonus or any sort of additional rate that has the effect of increasing the interest rate. So if I give you a loan at 6%, and then you default, and then I charge you a penalty of $10,000, which has the effect of increasing, that adding that $10,000 into the total interest that you're paying, or the total amounts you're paying, raises the interest rate from 6% to 7%, the effective interest rate, that is in contravention of Section 8 of the Interest Act, and that is not allowed. And that's the basis for a lot of, for the reason why a lot of these penalties are not allowed. And you can see just on its face, Section 8 of the Interest Act and Section 17 of the Mortgages Act seem to be sort of in contravention of each other. Because how can I say that you have to pay me a 3-month penalty, which would have the effect of raising the interest rate, the effective interest rate, and then say you can't do anything that raises the effective interest rate? So that's the tension between these two provisions. And that is where our first sort of big case that we're going to look at today comes in. And just for the lawyers in the room who are wanting the citations, I will, after this presentation, I'll upload my notes that has my end notes with all the citations and all the cases cited in it. So you can go look at these. I personally am a firm believer that all case law should be free to the public. So I only really use cases you can get on Canly. So you don't need to have a LexisNexis subscription to get all these, or go to your law library and ask for them to pull these old cases. But this is the sort of leading case on Section 17 and the tension with Section 8, Mastercraft and ELEF investments. So in this case, it's a mortgage case. There was a condition in the mortgage that in the event of a default, the mortgagor had to give 3 months notice in writing, or a 3-month interest penalty, or 3-month interest payment in order to obtain a discharge. And the borrower sued, claiming that this provision violated Section 8 of the Interest Act. And so, of course, this is where the court goes into the whole analysis of, do these two provisions work in tandem? Can Section 17 and Section 8 exist in the same world? And the court found in this case, on the facts, it was not a fine or a penalty, but rather a payment required for the privilege of paying arrears without the necessity of giving the 3 months notice contracted for. So I mean, this is a rough, a bit of a messy analogy, but you can kind of look at it in the same way as, you know, when someone is terminated from their job and they have to be given pay in lieu of notice, right? I can tell you, you're going to stop being employed by me in a month, or I can give you a month's notice. I can give you a month's worth of pay and you leave today, because, you know, the courts and the province and the country have understood that if I get fired today and I don't get any more money, that's hard for me. I need to go find a new job. Similarly, if you don't pay me this 3-month penalty, or this 3-month bonus, or this 3-month payment prepayment privilege, it's going to take me some time to put that money back out there and find a new job, quote unquote. And so in this case, the court found, no, this does not violate Section 8. And this is sort of the big block quote. The obvious purpose of such a stipulation is to give the mortgagee the benefit, when the mortgagor defaults, of a reasonable period during which to arrange for the alternate investment of its funds when the mortgagor does finally retire the mortgage paid off. If the mortgagor, which is the borrower, obviously for its own benefit, wishes to retire the mortgage at a date earlier than the termination of the 3-month notice period, it has the contractual right to do so, but must pay for that right in an amount equal to 3 months' interest. In my view, such a contractual arrangement is not what is contemplated by Section 8 of the Interest Act. The important language to pull out of this is the right. It's the mortgagor's right. So this is a borrower's right, or a borrower's privilege to do so if they wish to get out of the mortgage early. And that's important because courts since this case have, and even prior to this case, have found that the 3-month interest bonus, or 3-month interest penalty, however you want to put it, is what we call a shield, not a sword. So a borrower can rely on it to get out of a mortgage early by paying a small sort of 3-month bonus. A lender cannot rely on Section 17 of the Mortgages Act once they've enforced a mortgage, to turn this 3-month penalty into an obligation in addition to the principal and interest owing. So to unpack that a bit, I am a lender. I'm not, but in this scenario, I'm a lender. I lend money to somebody. They default. They just, for whatever reason, they miss a payment. They don't say, by the way, I want to pay out the mortgage early. Here's 3 months, and go. They just stop making payments. They stop responding to letters. They stop answering my phone calls. I hire Matt Gibson Legal, M. Gibson Legal, to enforce my rights. We issue a statement of claim. We get default judgment. They finally come up with new financing. They ask for a discharge statement. At that point, I cannot rely on Section 17 to say, also you owe me 3-month interest penalty. That is no longer the mortgagor, the borrower, relying on their privilege of a 3-month penalty to get out of the mortgage early. That is me imposing a penalty in addition to the interest, the principal, and my legal fees and all that. So the case that one of the leading cases on this is Ialongo and Serm Investments, where they state the amounts a mortgagee, a lender, may demand from a mortgagor upon enforcement are those spelt out in the mortgage contract, not in Section 17 of the Mortgages Act. So if you have a statement that says Section 17 3-month penalty after you've already been hit with a statement of claim or a notice of sale or a default judgment, that is not in accordance with the case law, and you can push back on that. This section, this sort of idea of a Section 17 versus 3-month penalty, there's a lot of case law still, sort of a lot of judicial ink being spilled over this, because there's case law that basically says if a lender wishes to enforce a 3-month penalty after enforcement, after commencing enforcement, it has to be specifically set out in the mortgage agreement or additional charge terms. So they cannot just rely on Section 17 of the Mortgages Act. They cannot just say, oh, it's my statutory right. It has to be specifically spelled out in the mortgage commitment, the standard charge terms, the additional provisions, somewhere in the actual contract that the borrower has agreed to. And even then, there's case law that finds it may only be enforceable before the mortgage matures. Once the mortgage has matured, from a policy perspective, well, you were expecting that the mortgage would mature and you'd have to reinvest it at that point. So why should you be entitled to a 3-month prepayment penalty after the mortgage has already matured? At that point, your right is to enforce the mortgage, collect the principal, collect the arrears that have added up, collect your fees, but you don't get this extra 3-month bonus just because they didn't pay it off on the day of maturity. I have had to fight this a number of times with private lenders. It doesn't always go as smoothly as I'm hoping, and we'll talk about sort of what our options are when it comes to actually disputing these things in a little bit. But that is sort of where the case law is on Section 17 interest penalty. It does not violate the Interest Act. It is a shield, not a sword for the borrower. And if you want to enforce a 3-month penalty after enforcement, you got to really put that very clearly in your contract. And even then, it may still not be reliable. Renewal fees. These are always the fun ones. I was actually having a conversation with a lawyer last night about these because their client got hit with something like $48,000 in renewal fees, which is insane on a discharge. So renewal fees, many private mortgages are short-term. The most common seems to be 12 months. Sometimes we're seeing shorter. Some people are thinking, oh, I just need this money for a short period of time, and then in 6 months I'll have better, I'll show better income on my statements, and therefore I'll be able to get a B lender or an A lender and pay this off. A lot of lenders do not actually have the organization to send out annual renewal agreements. But as long as the mortgage keeps paying, they just keep collecting those checks, right? When I act for lenders, I do try to diarize about a month out from whenever we put a new mortgage together. I will diarize 11 months from now, and we will send a reminder to say, hey, do you want us to send out a renewal? Do you want to renew on the same terms, offer different terms, et cetera? But a lot of lenders don't do that, or the renewal agreement never gets signed back. They forget about it. They keep collecting the checks. They keep, processing the payments, and just go on their way. As well, we often see, especially with the sort of more experienced private lenders, or the larger private lenders, an automatic renewal clause in the commitment or the charge terms, saying, if you do not renew or you do not sign a renewal back, the mortgage will automatically renew for this period of time at this increased rate with this penalty or with this renewal fee. And of course, this raises the question, is this at all legal? Is this enforceable? And what do we do about these? And so one of the leading cases that I always rely on for this is L Mortgage Corp in Sahota. This is a Toronto mortgage case. And I just wanted to sort of put the actual clause that was at issue here, because to me, it's just gross. But anyway, So the question, or the clause stated in the mortgage, provided that should the mortgage loan not be repaid in full on the maturity date, then and at the sole option of the mortgagee, this is important, the sole option of the mortgagee, the mortgagor shall be deemed to have accepted, and the mortgage shall be automatically extended for a further period of 6 months at a rate of interest equal to the rate of interest plus 3%. So we're jacking the interest rate of 3% automatically, together with a renewal fee equivalent to 5% of the outstanding balance. So realistically, we're actually jacking the renewal fee up 8% for the next year, because 5 plus 3 on that 1 year. Said renewal fee to be due and payable on the first day of the extended term, failing which the same will, at the sole option of the mortgagee, automatically be added to the then outstanding balance of the mortgage loan as principal. So basically, we're going to automatically renew it. We're going to increase the rate by 3%, and then we're going to add 5% to the principal, and then that's going to get paid out on discharge, in theory. So of course, when the borrowers went to go pay off their mortgage, they were quite shocked to find that their mortgage had basically gone up by 8%, and they were suddenly all these additional charges on their discharge statement. And so they fought it. And luckily for them, the court sided with them. The court found that this renewal clause violated Section 8 of the Interest Act, that section that says you cannot impose a fine or a penalty that has the rate of increasing the interest rate in this, or has the effect of increasing the interest rate, which in this case, literally increased the interest rate. And the reason that this violated Section 8 was this renewal, or this increase, was solely at the discretion of the lender. It came into effect the moment the mortgage matured and wasn't paid back, which is an act of default, and stated that such a clause was precisely what Parliament intended to invalidate with Section 8. So basically, the reasoning was, well, you don't pay the mortgage back on the date of maturity. Even if you pay it back the next day, at that point, you're technically in default because you haven't paid it back on maturity. And then the mortgagee, the lender, at that point gets to decide, all right, great, you didn't renew, now you're in default, I'm immediately charging you an extra 8% as a penalty for the fact that you are in default and that you didn't mature, or that you didn't pay off on maturity. And this sort of gets additionally compounded by the possibility that, okay, you've got this automatic renewal clause, but we're going to send you a renewal that says we agree to renew at a plus 2% plus a 3% fee. So your choices are increase or increase. And we get to choose which. If you don't choose the first increase, we get to automatically impose the second increase as soon as you fail to pay us back. Your third option is pay it all back on maturity. But if you don't have the money, you're kind of screwed on that. So what the court's sort of reasoning was is, yeah, you can't just do that. If your mortgage doesn't get paid out on maturity, your rights as a lender are to call in the mortgage and then go to enforcement if you have to. But you cannot just suddenly say, fine, we're renewing you at plus 3%, plus 5%, plus 10%, whatever. And this same reasoning applies to any sort of automatic rate increase upon maturity, as well as any automatic quote unquote renewal fees that get imposed. And this isn't to say that you can't offer a renewal at an increased rate or with a renewal fee. You certainly can, but you need to have the borrower explicitly sign a renewal agreeing to that. So we will often send out renewal agreements that say, the lender's willing to renew at the same terms. There will be a $1,000 renewal fee if you accept this renewal. If you do not want to pay that fee at this time, we can capitalize that renewal fee onto the principal. And then they will sign that back. And then we know, okay, great, they've agreed to it. We're not going to run into this issue down the road. But if we just try to automatically increase that and impose that on them, court says no go. And there are a number of other cases that sort of back this up. And again, I'll put the sort of the citations to that in my notes. But that's the leading case on this, and really sort of outlines all the reasoning as to why these automatic increases are contrary to the law. NSF, non-sufficient funds, missed payment, and other fees. So these come up a lot. you'll see them a lot on statements, and they're usually sort of, a few hundred dollars here, $1,000 there. So it's important to look at, again, at the legislation. Section 27 of the Mortgages Act specifically sets out how funds from a power of sale are to be paid out. So this is assuming that the property has gone through enforcement and has been sold by the lender or the lender's counsel. And Section 27 explicitly states, legal fees and reasonable enforcement fees get paid first, and then interest, then principal, then second mortgage, third mortgage, whatever. And there's a lot of case law that is, clearly established. A lender may lawfully recoup from mortgagors who are in default the administrative costs incurred caused by the default. So there is a cost to a check bouncing. There is a cost, as I mentioned, there's a cost to a lender failing to pay, or a borrower failing to pay on time. Sometimes the bank charges you $50 when a check bounces. Sometimes you have to spend time going back to the bank, spend time talking to the lender. Maybe you call your lawyer and you have to pay your lawyer a couple $100 to send a letter out reminding them of their missed payment. Those fees are valid. Courts have also established that such fees can be considered liquidated damages spelled out in advance in the contract. So the court in NRD, I'll show the citation in a second, said for good business reasons, such costs can be estimated in advance and fixed in a contract. So it is not unreasonable or unlawful for a lender to say in the standard charge terms, by the way, every time your check bounces, I'm charging you $200. That's a liquidated damages estimate of what it's going to cost me because of the bank fees, the time, the hassle, my call to my lawyer, etc. That's a reasonable fee for when you bounce a check. But the courts are very clear that such costs should be a genuine reflection of the costs to the lender. $1,000 for every bounced check is unreasonable. How is it costing you $1,000 because my check for my May mortgage payment bounced? It's just that's not reasonable. And so the courts have stated fees and charges levied on a mortgage default that are not genuine pre-estimates of costs actually incurred by a lender are penalties that can be void at common law and may violate the Interest Act. So it's important to make sure when you're looking at these NSF fees on your discharge statement, think to yourself, well, how reasonable is this? Is it reasonable that there's $5,000 worth of NSF fees? Probably not. One of the leading cases on this is what's known as the parcel case. And that was the issue, or one of the issues at play in this case was these, NSF fees, these default administration fees, these bounce check fees. There was, a whole slew of checks of fees under different names that the borrower was saying, how is this reasonable? And you'll see this sometimes on statements where you see default administration fee and then bounce check fee and then administration fee and then default fee. I've had that where I said, what is the difference between a default fee and a default administration fee and an administration fee? And the lender basically said, well, look at the contract. It's in the contract. And I said, it's not a valid response. And so the court found in parcel, or stated in parcel, in the absence of evidence that the charges in question reflect real costs legitimately incurred by the respondents, in this case the lender, for the recovery of the debt in the form of actual administrative costs or otherwise, the only reason for the charges was to impose an additional penalty or fine, thereby increasing the burden on the appellants beyond the rate of interest agreed upon in the mortgage. The courts have not hesitated to disallow similar charges on the basis that they offend Section 8 of the Interest Act. So again, we're going back to that Section 8, our best friend, Section 8. You can't just say, well, you bounced a check, and so there's a penalty of $500 because that made me mad and I want more money. That's not allowed. That's not legit. And so you can push back on these things, have them reduced to what's reasonable pursuant to Section 8 and this case law. So again, like I said, these are real fees I've seen on claims or on statements before: default administration fee, enforcement proceedings fee, collection administration fee. And it's important to note, these are not like the legal fees, because it's that's totally reasonable. Legal fees are totally reasonable. If I have to hire a lawyer to issue a statement of claim, to hire a process server to serve you, to go to court to get judgment, that's going to cost money and time, and I'm going to want to collect that. But when I see enforcement proceedings fee, $2,500, legal fees for enforcement, $3,000, Well, what's that $2,500 for? What was the lender doing that cost $2,500 to enforce this proceeding or to start this enforcement proceeding on top of what their lawyer was doing? And that's the question you need to sort of ask yourself. There's also case law, and I've run into this a number of times where, so often with private lenders or private borrowers, I should say, they're not doing pre-authorized payments like your bank or like an Olympia Trust is going to do. In these individuals, oftentimes it's just post-dated checks. Give me 12 post-dated checks, kind of like rent. If the mortgage has matured and I don't have any checks and I keep charging you NSF fees, even though I'm not depositing checks, what is that NSF fee for? Arguably nothing, right? No check is bouncing. I'm not going to the bank. I'm not spending time fighting with the bank over why the check bounced. I'm not being penalized by having a NSF fee pulled out of my checking account. So why are you charging me an NSF fee when you know the mortgage has matured and you don't have any payments and it's just every month is missing a payment? You don't just keep adding those on. So again, if you're looking at a mortgage and it's a mortgage statement and you know it defaulted 2 years ago and you got 2.5 years worth of NSF fees, that's a question to raise. I don't know if I've been talking way too fast or not fast enough or what, but the last sort of section I want to touch on is the difference between judgment and a discharge statement, because this does come up a lot of times when I'm talking to other counsel or to borrowers, and they say, you know, you got a judgment and now I've asked for a discharge statement and I'm looking at the discharge statement and there's all these other costs on it. That's not cool. You have to rely on the judgment. And there's an important case, Violi and McLeod, that basically says, no, it's very understandable that you would get judgment at one point in time, and then you would continue during your enforcement action to incur additional costs, legal fees, et cetera, administration costs that need to be recovered and added to the statement. And so basically in that case, the respondent, or sorry, the applicant in this case, Violi, was disputing the discharge statement saying, no, I've got a judgment. It said it was $400,000. Now I've got this discharge statement that says it's $420,000. I'm not paying that $20,000. I want my discharge. And the court said that after obtaining judgment, it would in the ordinary course, continue with its power of sale and incur further expenses, which it would charge against the sale proceeds. The judgment does not preclude the chargee, the lender, from claiming further expenses incurred in exercising the power of sale. And in my view, it does not preclude the chargee claiming expenses already incurred in respect of the power of sale where it has not claimed them in the action. So to parse that out a little bit, I draft a statement of claim from my lender and I'm claiming principal and interest and the reasonable fees they've already incurred. I then get judgment for that plus prejudgment interest. Well, during that time, I've also had to hire a property manager to check in on the property because it was abandoned. I've had to pay someone to cut the lawn. I've had to hire a locksmith. I've had to send multiple letters, emails, and phone calls to the other side's lawyer trying to negotiate this. I've then had to file for an order for possession. All these things are going to add up and add costs. They're not going to be reflected in my statement of claim. My statement of claim is for what I was claiming at the time the claim was issued. Things have changed. Things have continued. I may have even incurred fees prior to that statement of claim that I didn't include because for various reasons. I just didn't include, the administration fees of having a property manager go on and see it, go by and check on the property, see if it was abandoned before we even started our action. And so Violi and McLeod stands for this principle that you as a borrower cannot look at your judgment and go, this is all you get nothing more. I want my discharge. That's not, unfortunately, the case. So you do have to be aware that the discharge statement is sort of I'm not gonna say it's the final say because you can push back on that, but it is a valid reflection of the costs if those costs are legitimate. So this raises all these questions. It's great to know what you can and can't charge, but what happens when the lender sends you a discharge statement and it's full of all this nonsense? Where do you go from there? It's clean and straightforward, and yet it's, as with all things in the law, it's messy and complicated. But I'll tell you, I deal with this not every day, but more often than I'd like to, and it's rarely as straightforward a win as you're hoping. I know that Mark had to deal with this a few weeks ago, and it seems like he got a very easy, not a very easy win, but they basically backed down once he threw all of his weight behind it, which is great. And that's what we love to see, but it doesn't always happen that way. A strongly worded letter doesn't always work, but it is the first step. So what are we actually supposed to do? Practically speaking, unfortunately, we're often dealing with these issues days or hours before a closing, right? You've requested a discharge statement. Your client's property is selling on Friday. You get the discharge statement on Wednesday, and you're going, what the hell are all these charges? How am I supposed to deal with this? I don't have enough time to bring a motion. We need to sell this house. We need to close this deal. I'm not going to be able to deal with this. First things first, write that strong letter. And again, for the agents and the brokers in the room, get your lawyer to write that strong letter, citing the relevant cases, attach those cases, throw it at their face, say, no. LV Sahota says this, Section 8 of the Interest Act says this is BS. You cannot do this. And you can throw in those, we're not going to call them threats, but those strong statements saying that, if these extra fees are not waived, these unenforceable fees are not waived, and these prevent closing, we will be seeking my client's damages against you or against your client, really, due to this. So, we'll deal with this, and we're going to sue you after if you don't allow us to close because you're trying to charge things that are not chargeable or not enforceable. If they flat out refuse and say, well, do your best, we don't care, we don't believe you, or whatever. And this will happen a lot because oftentimes these are not massive amounts. Sometimes they are. In the case that I was talking to the lawyer yesterday, it was like $48,000. That's a big amount. That's gonna be, it's definitely gonna be worth fighting for either side. But sometimes these are $3,000-$4,000. And the lenders often know, or their lawyers often know, look, it's not worth your time and money to fight me on this. So I'm just going to be stubborn, and then you're going to take it and you're going to deal with it, and done. And that is a practical consideration that the lawyer is going to have to take into account. But if they refuse to change their statement and they say, no, we're relying on our statement, do with it as you will, there's sort of two main options. Number one, offer to pay the disputed amounts into court plus some amount for security costs, and then seek a motion after closing. So if we're fighting over $20,000, I'll say, you know what, we've got $30,000 that's going to be available to us from the sale, from the mortgage, whatever. We're fortunate enough to be in this situation. We're going to bring a motion. I'm paying this $30,000 into court, and we're going to come to an agreement on this with opposing counsel. You're not getting this $30,000. It's going into court, and then I'm going to bring a motion. I'm going to fight you on it. And if we're successful, I'm going to seek our costs against you as well. But in the meantime, you're going to give me the discharge for the, if it's $400,000 plus $30,000 disputed fees, I'm giving you $400. I'm putting $30,000 into court. You're going to give me the discharge, and we'll fight over that $30,000 after the fact. And that's one way to deal with it. Obviously, there's cost and time involved in that, and you do sort of need to come to an agreement with the other side that is the way forward. But that can certainly be an option. The other option is, if you have this available to you, if you've got the money, that there's going to be money coming in. Your client obviously wants that money, but for the short term, pay the fees, but do so under protest. Make it very clear, we are not admitting that these fees are valid. We are not admitting that payment of this constitutes a waiver of our rights to recover these fees later. And we will sue you after the fact, oftentimes in small claims court if it's under $35,000, or if it's a significant amount, maybe in superior court. I have seen some letters from lenders and from lenders' lawyers saying, any payment of our fees is a waiver of all rights and an admission of the validity of these fees. I don't care. I don't care what you put in your letter. I'm going to protest it. I'm going to make it very clear that this payment is being done on a without prejudice basis. And you can put whatever fine print you want in your letter. You can't impose that on me. So that is option two. I'm dealing with this on a couple of matters right now. I spent most of yesterday fighting with Scotiabank over $5,000 on an automatic renewal that I don't think is valid. So this stuff happens, and there are ways to deal with it. It's not always as clean and fast and easy as you hope, but sometimes it is. So this is this is the backbone for those arguments for you.
Matt, can I stop you for a second? She Hang has asked, what happens if there is no exculpatory language from the other side saying that you're giving up your rights to sue, and you don't write that you're closing under protest? Do you have to say that you're closing under protest to preserve your right to sue as a matter of course?
So I haven't seen, specific case law or legislation on that idea. My opinion or my position would be no, I don't believe so, because if these fees are in violation of the legislation, they're in violation of the legislation, whether you consent to them or not, right? And so, it'd be my position that, well, we didn't specifically state that this payment was done without prejudice. These payments are contrary to the law, and therefore were never enforceable, are not enforceable, and therefore, we're going to be seeking them back.
Thank you.
Again, best practice, always make it very clear. But maybe you paid something a couple of days ago, and now you're thinking, oh wait, maybe we should have fought those. I would still bring the fight to them and say, look, these fees were not enforceable and were never valid.
One more question from Josh.
Yeah.
Josh, what about situations where the lender's lawyer refuses to accept funds and discharge unless they receive full and final funds without protest?
Then you're going to have to bring some sort of emergency motion, unfortunately. And again, I think, yeah, I mean, your options are bring an emergency motion or pay them and, sue after the fact, and make it, that's a very difficult situation, because if your lender refuses to discharge, your really only option is to strong arm by getting a court order. And unfortunately, that's going to take a lot of time. Now, there are emergency motions you can bring, and hopefully the other party involved in the transaction that's maybe relying on a sale to close or a mortgage to close understands the delay. But yeah, I think a court order is going to be your best bet if you can. If not, make the payment and sue. And I haven't. Unfortunately, I haven't dealt with that issue where I've had something slapped down after the fact because we didn't, because the lender stated no, this is with prejudice and you have no rights. I haven't encountered that yet. I'll do some digging later and maybe see if there is some actual case on that, but I haven't encountered it. But I don't think that. In my opinion, I don't believe that the other side can impose that this is with prejudice if you don't agree to it. But if they're just refusing to discharge, I mean, you can bring that in order. You can seek those costs and penalties against them, because they're going to be causing damage to your client, delaying deals and what have you. And that's a dangerous position for them to be in as well, right? And that's also the situation where we don't like to do this as lawyers, but if another lawyer is being particularly obstinate and is going to cause significant financial damage to your client, then it might be the time to say, if you don't do this, if you don't agree to allow us to pay this under protest, we're going to seek damages against your client and against you personally. And that might put them on their back foot a little bit more as well.
Excellent. Maybe we can just have one more question quickly.
Sure.
Sully, do you want to ask your question? Unmute yourself and ask your question, Sully. Let's make this more lively. Let's get some people involved. Nope. All right. So there we go.
Hey, sorry, there we go, connected. So is there any way you could pay them the full funds and then get the discharge, and then pursue them after? Or would it be basically just kind of taking the fees and not able to do anything about it?
No, so I've done that several times where we pay the full amount, get the discharge, and then we bring a claim after saying we want that these contested fees, we want them back. These are our damages. You forced us to pay something that we don't think you were entitled to. We did it under duress. We did it because we had to in order to get this discharge done. But now we're seeking those repayment of those fees. Okay, so I think this is it is my last slide. So sorry. So what did we learn? to sum it up, and like I said, I'll have the slides as well as my notes that are a bit more detailed with some citations posted to the forum. But 3-month interest penalty can be valid, but cannot be used as a sword. if you do want that 3-month penalty or that 3-month bonus in your private mortgage after commencing enforcement, you need to have specific language drafting that in. And even then, it may not be enforceable depending on the circumstances, but you cannot rely on Section 17 alone to give you that penalty after enforcement. Number 2, automatic renewal fees and interest increases are generally unenforceable if they are at the sole discretion of the lender after the mortgage matures or defaults. And bank fees and other administration fees must be a genuine estimation of costs incurred by the lender upon default. They cannot just be willy-nilly $1,000 here and there because I'm mad that you missed a payment. So that is the long and short of it. I understand there's a lot of information there, and I'm happy to talk to people offline after this when I'm available. And I guess I'll turn it back to Mark to see if there's any other questions.
Terrific. Thanks, Matt. So guys, there's a reason that Matt is the one presenting this. He doesn't want to claim to be an expert, but as you can see, deep experience and expertise are they tread the same line. Vishal has a question. So Vishal, why don't you unmute yourself? Guys, we have a smaller group today. We have about 40 people here. So anyone who wants to unmute themselves and ask a question, or just put your hand up and then I'll call on you and you can ask your question verbally. Go ahead, Vishal, you're up next.
Yes, and thank you, Matt, for this informative session. It was really, really helpful. One of the things that you rightly said that, we are certainly dealing with these issues of cost at the very last moment. And I believe that's a tactic from the lenders or their lawyers that, they want to send it on, the morning that the transaction is going to close. So they have to deal less with these, cost issues. But this is a good idea, like, sending out them a letter that these are the case laws that would apply. Now, drafting that, all those things, probably at the last moment would be really tedious. I don't know if you are using that, any template or any set email or a letter that you already have that. You just change.
Yeah, I certainly have a couple. If you send me an email, I can send you a couple samples. I also know Mark posted one, I believe, on the forum a couple of weeks ago, sort of what he had written that was quite well drafted and got him the result he was looking for. So obviously it worked.
I want to be clear that the reason I got the result was because I was dealing with a very good lawyer on the other end who was cooperative and wasn't trying to be egregious. So just to be clear, this wasn't my genius. And frankly, I was taking mostly what Matt had given me and putting it into writing. So let's not think too highly of.
I'm just trying to divert attention back to you.
Sanchita has a question for you. Sanchita, please feel free.
Thanks, Mark. Thanks, Matt. This was really good. I don't actually have a question, but Matt, I just wanted to thank you for taking the time yesterday to talk to me through it. So guys, the secret's out. It was me that he was talking about with $48,000 in renewal fees.
Yeah.
I spoke with Mark. So Mark, Matt, thank you so much. This was so helpful. I've been in contact with the other lawyer and we're hoping to resolve the matter today. So I really appreciate this.
Wonderful. Glad to hear it. Yeah, to Mark's point, it often does depend on the rationality of the lawyer on the other side. And to be fair, their client, right? A lot of times we are working with, we know the law, we understand the law, but we have a client that just says, I don't care. This is what I always do. And I get that all the time. And I have to educate them on, this is what I had this conversation yesterday with a lender who had an automatic renewal or an automatic increase clause that jumped it up to 18%. And I explained to him yesterday, this is not enforceable. And he said, well, I didn't know that. No one's ever told me that. If I had known that, I would have started enforcement 6 months ago when they defaulted. I was just sitting here thinking I was getting 18% a month. And I said, no, you're getting 9%. And he said, okay, well, now I know. Why do we even put it in there? And I said, well, someone put it in there 6 years ago and never got caught on it. And now you're relying on erroneous information. So.
All right, so guys, as always, we will have a copy of this recording placed on the forum. Matt, if you want to just email me your slides, I will upload them at the time that I upload this, just so it's a cohesive sort of thing. And guys, I can't thank you all enough. I know it's summer months, and so our numbers are usually a bit down on our videos. But nonetheless, I think this is probably one of the most informative sessions and most instructive because so few of us actually know the ins and outs of this area, which make us all better counsel. So Matt, we're incredibly grateful for your time, for your expertise. And though you may not be an expert in the area, I'm very happy we had an expert prepare for us and present to us today. All right, guys, I'm going to wish you all the, oh, we have one last question. Can we sneak one last one in? Because we still have 4 minutes.
Sure.
All right, Andrea has a question. Go for it, Andrea. Ask your last question just before we go off. And then once you're done and once Matt answers, we'll call it to a close. Andrea, no, you there? You are, maybe you're having trouble with muting.
So I'll read it out loud.
fine.
So once in a while, we come across a borrower who is strategically choosing not to pay back private mortgages for business reasons. For example, a borrower who took a loan for real estate investment from my lender client clearly told us via their counsel they decided to buy another property instead of paying my client out on maturity. I've had that too. In your opinion, is this a situation where the court could rule in favor of the lender on a 3-month penalty after default? I'm hesitant to give an opinion on a very fact-specific matter like that. Again, it's going to largely depend on the language in the contract. If they have specifically stated, you know, upon default, if the repayment upon default is subject to a 3-month interest bonus, then I think that the court could very well find in favor of that. If they're solely relying on Section 17, there's nothing in the contract about any sort of 3-month penalty, you're going to have a steeper hill to climb for sure.
All right, and with that, we're going to call it to a close. So Matt, thank you again. Let's get this recording up. And everyone, it goes without saying, and you probably figured it out, if you have enforcement issues or if you need power of sale help, competent professionals like Matt and others, but Matt is the one that we all seem to know, are there to assist you, and you do not need to be helpless when dealing with abusive tactics from other sides. There is case law to help you. There are professionals to help you. And we thank you sincerely for educating yourselves and making yourselves better counsel, better realtors as a result. Take care, guys. Have a great morning.